Hello and welcome to my latest evidence video capsule. And today I want to look at something pretty important for evidence law. I want to look and examine the principled approach to evidentiary admissibility, an approach to evidence law that has been slowly revolutionizing the way we approach the law of evidence to begin with. The principled approach essentially moves us from where we used to be, a system of fixed evidentiary rules with certain exceptions that had to be satisfied before evidence could be admitted, to where we are slowly going, where every evidentiary rule is really about the application of principles which allow for flexibility to deal with each evidentiary system on a case-by-case basis. What I want to show you in this capsule is that there are really pros and cons to each of these approaches, and neither is perfect. And I'm going to do so by looking at this in the context of a recent Ontario Court of Appeal case, the case of Kahn, a 2017 decision that really tackles head-on the question of whether or not it is a good idea to move all evidentiary rules to the principled approach. Now, Kahn takes place within the context of the rule against prior consistent statements. And what's interesting about the case, what I like about it, is the facts are straightforward, really easy to get a sense of, and the evidentiary issue the court decides. They're actually unanimous about, the result in the case. Everybody agrees that this evidence should be admitted, but where the complication arises is with respect to how should we go about admitting evidence. And in particular, in this case, they're dealing with a particular rule, the rule against prior consistent statements. And the question becomes, how do we address these? So let's just talk very quickly about the case. It's really quite straightforward. A woman's arrested, and she alleges that the police essentially sexually assault her. The evidence is that the officer searches her 3 times, does a pat down on her chest. You can read the facts yourself. Very straightforward. She becomes upset and angry when the female officer asked to search her at the police station. And I think, and the court agrees, that this evidence is very revealing. It is a prior consistent statement, for those of you not familiar with the rule, because in court she testifies that this is what happened. So she tells everything that happened in the original search. But she's not allowed, because of the rule against prior consistent statements, to testify about what she says to the female officer. Okay, so the prior consistent statement rule excludes that and also prevents the female officer from testifying. That is a basic application of the rule against prior consistent statements. Now here's where it gets interesting. Sort of, how do we get to the admissibility of this statement? And to be clear, this is a Crown appeal. The statement is admitted at trial. And the guy is convicted. And then it goes up to summary conviction appeal, and it's overturned on the basis that it was an inadmissible prior consistent statement, and then the Ontario Court of Appeal reinstates the conviction by going through this analysis. Now here's the thing. What's interesting is that the majority looks at the basic approach to evidence law, which is a structured approach with a rule and exceptions. And that is the way evidence law has traditionally approached the rule against prior consistent statements and, many other law rules in the law of evidence. So the prior consistent statement isn't admissible. There are numerous established exceptions. They list them off, and then they go through the particular piece of evidence in this case, and they find that it is admissible as circumstantial evidence. And the majority says this is narrative that is useful in assessing the credibility and reliability of the complainant's version of events. So that's really what it is. It's essentially, it's narrative in that is how the complaint came to be. So it fits into this idea of narrative of how the complaint came to the attention of the police, and therefore it's useful in the sense of assessing their credibility and reliability. So it's a fairly straightforward approach to the way in which we approach evidence law, rule and exceptions. And that's sort of where this gets interesting. Justice Doherty, who in my opinion is, arguably the best judge on criminal law and evidence issues in Canada, comes out and says, no, it's time to get rid of this basic approach to statements. The fact of the matter is, the admissibility of a prior consistent statement should be measured by its probative value. Okay? And if it's admissible, that's how you should do it. Forget about the technicalities of established exceptions. We're going to sweep those away and just have, really what this is a principled approach. Any of you who are familiar with hearsay law would know that hearsay law has a quasi-principled approach. I'm going to talk about that in just a moment, because the truth of the matter is hearsay doesn't have a completely principled approach. It uses a mixed system of principled and established exceptions. But Doherty JA says, no more of this. Let us look at the broader considerations rather than technicalities of established exceptions. So both sides agree that the evidence is admissible. So what's going on in this case? Like, what's it actually all about? Well, the answer is it's actually about a lot, and it's actually about the future of evidence law and the way in which we decide how to approach evidentiary admissibility. Because what these two judges are really arguing about, to the extent they're arguing, is about a fixed approach versus a flexible approach. And the majority in this case, Justice Horrigan, was arguing for a fixed approach that says that prior consistent statements are inadmissible unless they fit within the boundaries of an established exception. Period. Because that's a good way of doing it. Justice Doherty says, no more exceptions, a principled approach that says a prior consistent statement is admissible if it's relevant and material and has probative value. That's it. Who's right? Well, that's the complicated part. You can make a case that both of them are right. There are benefits and drawbacks of each approach, and the Canadian courts have not developed a clearly consistent approach for every single situation. And as I'm going to posit at the end, I'm not sure that they should. I think we are going to have to approach different evidentiary rules in different ways, although my feeling is the mixed approach, like the hearsay rule that has a combination of exceptions and flexibility, may ultimately come to dominate this particular area. So first of all, let's talk about the benefits of the fixed approach. And I'm going to do this in terms of benefits of the fixed and downsides of the fixed, because to be honest, they're just opposites of each other in the sense that the benefits of the fixed approach are the downsides of the flexible approach, and the downsides of the fixed approach are the benefits of the flexible approach. That's sort of the way this works. There is no perfect answer. The benefits of the fixed approach is that they provide structure and coherence. It's actually much easier and quicker to apply a rule that has a designated areas of exceptions, A, B, and C. And if you have that sort of rule, the question is, well, does it fit here? No. Does it fit here? No. Does it fit here? No. Then it's out. It's very straightforward. It's methodical. A computer could do it, right? You're just moving through certain things. And my experience in teaching evidence over the last 16 years shows that students and judges and obviously lawyers to a certain extent really like fixed approaches because they are easier to understand and apply. The law of evidence is actually really complex and requires a great deal of thinking about various matters in terms of being able to apply them on the go in a quick and easy time, in a time, I should point out, when we are concerned about cost and delay. The benefits of the fixed approach is that cost and delay is reduced because it's easier to understand the way we should go forward. But it's not all peaches and cream. The truth of the matter is the downsides are huge. The correctness, you can get it wrong. The exceptions are just that. They are generalizations that don't apply in every single situation. And a case like Khan is actually a good example of that. In my opinion, Khan doesn't really fit into the narrative exception. And the reason for that is the narrative exception is really designed to explain how things got to the attention of the police because that's important in understanding the overall aspect of the case. So there's some delay, for example, or there's some aspect of the case doesn't make sense, usually a disclosure issue. Well, why would it take so long for them to come forward? This isn't really like that. The narrative of the case wasn't really helpful in understanding how it got to the police. The reason this evidence is so important is because of the way in which it was transmitted. So now they're starting to create this, narrative as circumstantial evidence, whatever that means. So we're starting to get, the problem with exceptions is that the categories can become over or under inclusive. You start to have these categories that don't really make sense, and before you know it, you have to create new exceptions. So the problem with a fixed approach is that it can become complicated in its own right. But the benefits of the discretionary approach is you have a much better understanding to be able to apply each scenario carefully. And that allows for correctness, arguably, to take place. Let me just say that's not perfect either. Correctness becomes a very difficult thing to get to sometimes the more complex the various variables are in play. There is no perfect answer here, and that's probably why the courts have taken so many different approaches in the law of evidence. In fact, if you look at the law of evidence as a whole from a broader perspective, there are at least three different ways you can look at these models that exist in Canadian law, and you can see there's a lot of tension in the courts in trying to decide which way to go forward because of the mixture of benefits and drawbacks that I just explained to you. So with the prior consistent statements, it seems to me that the focus is a rule, exception, new exceptions. There is no principled approach to the prior consistent statement rule, or no court has advocated for that yet. The hearsay rule is a really complex scenario where we have a rule, we have like 50 various exceptions that exist that continue to be maintained, but then there is a flexibility to either disregard the exception or come up with a new principled route to admissibility. So you have this mixed model. And then finally, you have my own interest, the area of prior convictions of the accused being used to test credibility, where the court refuses to put any structure in at all and just says it's a free-for-all with complete and utter flexibility. Is it more probative than prejudicial? Another example of this is post-conduct evidence of the accused. That's another area that I think could use with a little structure, but instead is pretty much full flexibility, allow the courts to decide on a case-by-case basis. And all of these have strengths and weaknesses, in the sense that the ones that have more structure are easier to apply and quicker. And the ones that have moderate structure are somewhat easier to apply, and the ones that have full, complete flexibility are argument and discussion every time you want to admit this evidence. Frankly, more appeals. There are lots of drawbacks to full flexibility, but there are benefits as well, and that is part of the problem here. The law of evidence is struggling to decide which way it wants to go. I think what's happened is during the time of what we call the principled revolution that really began in the 80s, the court realized that fixed exceptions are problematic. And now they're just still trying 35 years later, to sort of decide, well, what is the way we should approach the law of evidence? And what I think is slowly emerging is I think we are slowly going to a mixed process. And I actually, if you ask me which one's going to win, I actually think in the end it's the hearsay rule, which has this mixture of flexibility and fixed exceptions that is likely to win the day. So I think what it comes down to in deciding which way forward, ultimately we need to look at the questions of complexity and risk. Because I think the issue of lawyers and judges having difficulty dealing with something, complexity, is very real to me. And at the same time, I think the risk of getting it wrong, what are those risks, is also something we should be concerned about. So that is why in some areas I believe that full discretion makes sense, and in other areas I don't think it does. And really it comes down to considering these two factors. So for example, with a prior consistent statement, by and large, I think I tend towards the understanding of the majority in con. And the reason I say that is because although it would be nice if we could approach every single prior consistent statement from first principles, really, it's not clear to me that that's practical or going to make life better for us in the long run. With a fixed approach, the truth is you may occasionally get things wrong, but over time, the benefits of proceeding in that matter, in terms of delay, understanding, etc., are much heightened. And I don't think with prior consistent statements, to me, the risk part of this equation is more minimal. And I say that because I realize that prior consistent statements are risky in the sense that they do have the potential for prejudice, but it's pretty muted prejudice. Essentially, the evidence is just matching evidence that's already in. So you're not like admitting something completely new that no one's ever seen before. So to me, the risk is fairly muted. Where in contrast, I think with prior convictions, I think the risk is incredibly high. It seems to me that in those areas, the complexity of the current discretion to admit prior convictions is more than most people can handle in the terms of the various factors that they're supposed to weigh. And I think a fixed rule that said we will exclude many of these prior convictions and admit several others, in the long run, is more beneficial. I think the risk is muted in that way if we actually create a more fixed sort of rule. And ultimately, I think the courts need to come to grips with this question of how we wish to approach the law of evidence. Because right now it seems like they're sort of trying to have it both ways. I think there has been a sort of failure to sort of reconcile at a global level where we wish to go with the law of evidence, and really in what circumstances we wish wish to be more precise about the types of exceptions that are permissible and whether or not a discretionary framework actually makes sense. So to me, the Khan case is a really interesting one in that it sort of puts on the table, without perhaps going through all the implications of doing things in this way, this question of complexity and risk. And it sort of raises the question for future courts about how they should go forward. Now, one last point. This is going to be a consistent theme that I raise in my capsules over and over and over again. One reason that it's so difficult to get guidance in this area is that this is an area that's not really well suited to common law courts to resolve. And what I mean by that is the common law courts are being asked a question on an individual rule of evidence in an individual case. So Justice Doherty quite logically says, well, flexible makes sense, principle makes sense, let's go forward. But what's irritating about this to me is that this is a real philosophical question about the law of evidence across a variety of doctrines. And what would make more sense, really, as they have done in other jurisdictions, is to have a review body which can actually look and try and get evidence on the way in which these things actually are applied in the courts, some empirical evidence, and look at the various philosophies from a more global, abstract perspective to try and advance the law of evidence as a discipline. That's really tough for the courts to do. I don't even blame them for not getting it right or not doing it properly, because it's really tough for the court in the abstract to look over a great body of evidence and try and make a decision that makes sense in every situation. That's what reform bodies are for. And if Canada actually had a reform body, maybe it would start to deal with these difficult evidentiary questions in a more principled manner. I think the courts are doing the best they can. I think Khan is a good example of the courts trying to figure this out. But ultimately, this is an area of the law of evidence, if it's ever going to be sorted out, needs to be addressed in a more global and systemic way. In any event, I think the principled approach and principled questions about evidence law are really important ones going forward for how our courts are going to deal with difficult questions of proof. In any event, that's more than enough for this video capsule. I hope that was of interest to you, and have a great day. To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.